funds is a critical step to scale any startup, but most Nigerian founders focus solely on the raising of the funds and they don't pay quite as much attention to the legal and the regulatory aspects of raising the funds, the process of raising the funds, and what happens after the funds have been raised. And today we're going to be diving deep into the basics, the legal basics of fundraising. What kinds of funds can you raise, especially in Nigeria? What are the laws that regulate fundraising and where the funds come from? What happens after the funds have been raised? Who bears the burden of paying taxes? And as many questions as you have regarding the legal aspects of fundraising. In Nigeria, there are multiple ways that you can raise funds. You can either bootstrap, that's you use your personal monies to fund the startup until it starts to generate its own income. You can either get money from friends and family if they want to contribute to your dreams. You can get money from an angel investor. That is someone who has, the financial capacity to fund your dreams, can, give you that money through any means that he or she or they, if it's an institution, desire. You can either get the money or you can either raise funds from a venture capital, which is the one we see the most often with startups, which is basically, venture capital is basically like an institution that invests in up and coming companies for a return. Usually in return for either cash, equity, whatever, but it's obviously always for a return. You can get funds or you can raise funds from grants by institutions, whether it's government institutions or private institutions, or you can earn capital or gain capital from competitions. You can enter hackathons and a bunch of other tech-based or tech-related competitions, and if you win it or if you're part of the runner-ups, you can get a certain cash prize. You can also crowdfund. That's when you invite the general public to invest in your particular goal or your particular startup or solution or whatever it is. But it's quite different from an initial public offering, which is another way that you can raise funds, where you invite the general public, now this time with the approval of the Securities and Exchange Commission, to buy shares in your company. And your shares will be priced at certain amounts, a certain number of shares for a certain amount sold to the general public. You can also get funds or you can also raise funds through debt, which is basically loans from banks, from other fintech institutions, or from any other institution, really. It doesn't have to be fintech specifically. You can also raise funds through equity or equity-based fundraising, which is the one that VCs, angel investors mostly use, where they get a share of your company to give you the money. Or you could raise funds through an ICO, which is like an initial coin offering. It's basically fundraising through blockchain-based tokens. Now, each fundraising method, from ICOs to bootstrapping to IPOs and VCs and whatnot, they each come with their own legal and regulatory requirements. And each of these requirements are regulated by certain bodies in Nigeria. Now, Nigeria has the Corporate Affairs Commission, which are the general body for, or rather the overseeing body for all things companies. So the management of your companies, the formation of your companies, and every single thing that has to do with the operations of your companies is managed and reported back and regulated by the Corporate Affairs Commission. Then you also have the CBN. They are like the governing body for all things money and finances in Nigeria. Then you have the Securities and Exchange Commission, they are the ones in charge of the capital market, in charge of assets. If you want to, have an IPO, you have to get qualification or certification rather from the SEC and, all things capital and assets and the general public involved. Then you have the Federal Inland Revenue Service, which currently they are being renamed by virtue of the new tax laws that have just been assented to by the president, which we'll get into in a whole other video. But for the purposes of those who don't know about the new law, I would still call them the Federal Inland Revenue Service, who are in charge of taxes and taxation, federal taxes and all that has to do with that. Then you have the Data Protection Act / Commission, the Data Protection Commission, which regulates the Data Protection Act. And they are the ones who are the regulators of all things data. If you collect data, if you use data, if you process data, they are going to regulate you. Now, for each of these bodies, they don't always apply to each and every aspect of fundraising. What do I mean by that? The SEC, for instance, Securities and Exchange Commission, they only deal with public capital, crowdfunding, IPOs. They only deal with public-facing securities, public-facing capital and assets. But if it's more private, they don't necessarily interfere with that. But other regulatory bodies such as the Corporate Affairs Commission, CAC, they have far-reaching capacities because they are the overseeing body for all things corporate and all things companies in Nigeria. So if you're going to raise funds, first of all, you have to be registered with the CAC. You cannot even conceive or even start to think about fundraising if you are not registered with the CAC, or if you don't even have your tax ID with the Federal Inland Revenue Service. You know, make it make sense. How do you want to raise funds when you're not an actual company and you don't have a tax ID? You see, there are different legal considerations for each type of fundraising, and we'll take it from the very beginning. Now, equity financing is you sell your shares for cash, or I give you cash, you give me certain shares in your company, aka I would own a certain part of your company. Now, the key legal requirements for you to be able to do equity financing is, number one, again, you must be registered with the CAC. You must be a registered entity with the Corporate Affairs Commission. You must issue proper share certificates to investors, aka your cap table must be put together, and once an investor invests in your company, you have to issue them a share certificate for that and add them to the register of members in your company. You should also have a shareholders/investor agreement with the incoming investors. Now, normally you might have in-house investors/shareholders even before you accept external funds, and you might have an existing agreement with the in-house shareholders. Now, when you have an investor come on board, you have two options. You can either amend the existing shareholders agreement or make a brand new one, or you can create an investor agreement that is going to service investors separate from shareholders. But generally, it's wise to do both. Amend the existing shareholders agreement and create an investor agreement so that the roles of the investor in the company is separate from the roles of the general shareholders while still being able to coexist. Another thing with equity, another legal requirement for equity financing is you have to have the approval of SEC, especially if it's, again, a public-facing thing where you're inviting the public to invest in that company, either through crowdfunding or through an IPO, or if the capital is so huge as to require the approval of the SEC, or even if they are from large-scale investors, because there are some accredited investors that will make SEC pause and take a look at your company. Now, with equity financing, there are some common mistakes that founders who are not aware make, which is giving people shares without documentation. Now, I've seen this thing happen a lot of the time, where you're building something and you're giving out shares anyhow, really, without proper documentation, or worse, you're giving out equity for a company that is not yet registered. You're giving them equity based on your idea. I'm sorry, but it does not exist. If you are the founder doing that, please stop doing that. If you are the developer, the independent contractor accepting equity for a company that does not exist, please stop doing that. Okay? There must be proper documentation for whether it's an investor or it's an independent contractor. There must be proper documentation that follows the trail of that equity. Where is it going to? Where is it coming from? You must properly document it. What are the rights that are attached to it? What are the obligations that are attached to it? You must document it all. Another mistake that founders or even startups usually make is ignoring the preemptive rights of existing shareholders. As I said earlier, when you get in a new investor, there's usually at least one or two other existing shareholders. And those people or those institutions, they have rights as shareholders of the company. And any new investor that comes in has to recognize the fact that they have existing rights. You also have to respect it. That's why it's best to create an investor agreement as well as amend the existing shareholders agreement so that everybody is on par and on the same page, so that there are no conflicting rights or obligation. Another mistake is giving out these shares to investors, especially institutional investors, without amending your Corporate Affairs Commission documents, your CAT documents, or your incorporation documents. Traditionally or typically, when you add on a shareholder to your company, you are supposed to remit as much to CAC to tell them that, hey, we have invited XYZ person as a shareholder in our company, and you are supposed to make those post-incorporation changes to your CAC documents. The types of fundraising that are categorized under equity financing: you have IPOs, you have VCs, venture capitals, you have angel investors, you have crowdfunding, because you give them shares in your company and they give you cash for it. Another type of fundraising is convertible notes, simple agreements for future equity, aka SAFEs. These are situations where investors buy a stake in your company that they can redeem later. So they buy the option or the right to invest or to have ownership of your company at a future date, aka simple agreement for future equity. Now, just like with equity financing, there are several legal requirements. For instance, you have to register the convertible notes or SAFEs with CAC and in your documentation. You have to clearly define the valuation, conversion terms, and a whole bunch of other clauses, important clauses that you need to add in your agreement. The thing with SAFEs and convertible notes is that they are quite synonymous. Their legal requirements, that is, are quite synonymous with those of equity financing. So they are almost basically the same thing, so that I don't have to repeat myself again. Another type of fundraising is debt financing, where you basically collect loans from an institution, an individual, or a bank, fintech, whatever. It's basically a loan against a collateral. And the collateral used to be real estate, but now we've grown to the point where you can collect a loan against your company or against future revenue that you will make. Now, per usual, with all things legal, you have to document any loan that you collect, properly documented, so that all parties involved, from yourself as a company to your fellow co-founders, shareholders, to the government, CAC, SEC, and all of that, all involved stakeholders are aware of what is going on with your loan and the terms that guide that loan. Now, the common mistake that you obviously should not make is don't take loans with any unclear terms or any terms that are unreasonable. Do not borrow from unregulated lenders. It's, for instance, now in Nigeria there are loan companies, and in several other countries too there are loan companies, but in Nigeria there are some loan companies that are accredited and others that are not. Do not go taking loans from unaccredited agencies or lenders, because when you enter trouble with that, the law will not help you, because again, they are not accredited. I mean, the law will help you to a certain extent, but for your own peace of mind and safety, just go take loans from accredited lenders and agencies. Another type of fundraising is crowdfunding. And crowdfunding is very similar with IPOs in the sense that you are inviting the general public to invest in your company. However, the difference is that with crowdfunding, there is a limit to what you can raise when you crowdfund, as opposed to IPOs where there is basically no limit. Once you've gone public, you have gone public. Now the general public has the right to buy shares in your company in perpetuity, unless you re-register your company from public to private. But with crowdfunding, you can crowdfund even as a private company. You don't have to go public to crowdfund. So those are one of the the minute differences. But either way, whether you're crowdfunding or you're giving an initial public offering, either way, you have to be registered with and accredited by SEC. Now, you can only crowdfund from SEC-approved platforms, and there is a limit to the amount that you can crowdfund from. I think it's about 100 million for micro enterprises to like 500 million or thereabout. So there is a limit to that amount. That's one. Two, you can only crowdfund with SEC-accredited investors, and with each investor, there is a specific amount that they can give to a crowdfunding endeavor, as opposed to an IPO where it's like the general public and there really isn't any limit. Now, the mistakes that most people make with that is they raise funds through unregistered platforms. As we said earlier with debt financing, don't go raising crowd funds without, the approval of SEC or from unregistered platforms. That's just wrong. The second mistake is offering shares to the general public without first registering with SEC. you might lose all the money you end up making. It's way more trouble than it's worth, so don't even contemplate that. The mistake is when you fail to disclose investment risks to your investors, whether it's crowdfunding the general public or IPO the general public. When you don't inform them of the risks that come with it and then you just raise funds like that, at that point you have a fiduciary duty to be, accountable, to be fair, to be honest and all that. And if you don't keep up with that, you will end up losing all that money. So again, be fair, keep up with all your fiduciary duties, inform your investors, the general public, of the risks that come with that particular investment. Now, another type of fundraising is grants and competitions. This one, most people consider it as free money, in quotes, because once you get it, it's not like a loan where it's like you have to repay it back. Nor is it like equity where it's like for shares in your company. It's a grant to do XYZ, so it's a grant. Or it's earnings from a competition, so it's essentially yours to do with as you please. However, there are still legal requirements that you need to keep up with. For instance, you have to ensure that the grant agreement specifies that it's a grant and the conditions of fulfilling the grant, or if you have fulfilled the grant, the conditions of using the particular money. Because there are some grants that come with specific things that you must do with the money or things that you must not do with the money. So you have to have a grant agreement that specifies all that. You have to also register that grant with the FIRS so that you can pay the appropriate taxes on it if it's necessary or if it's required by the grant provider. Some of the mistakes that people make or companies make that you should not make include accepting grants with restrictive terms that don't comply with your business goals. Again, you need to understand the terms that the grant provider is giving you, because not all money is good money. Second mistake is not keeping financial records of when the grant came, how the grant came, and what you used the grant to do. Because there are some grant providers that will, demand that you tell them what you use the money for, how you use the money, and a whole bunch of other restrictions that might come with it. Now that you understand the legal requirements, first of all the different types of fundraising and the different regulatory bodies that regulate fundraising in Nigeria, and the compliance requirements involved, and the legal mistakes not to make, what are the tax implications in fundraising? Who pays the taxes? Well, there are several types of tax that apply in fundraising. There are capital gains tax when investors sell their shares to buyers and whatnot. Capital gains tax, which is like 10%, will apply. There's also withholding tax, there's also stamp duty tax, and there's also VAT, value added tax. All of these taxes apply. Now, at what point do they apply? It now depends on the facts surrounding the money. How did you get the money? What did you do with the money? And so on and so forth. Sometimes only one of these tax will apply. Other times, all of them would apply, from VAT to withholding tax to capital gains tax to stamp duty. So again, it depends on the facts surrounding the money, where the money came from and where it's going. Now you're a founder and you're probably thinking, wow, this has been a whole lot of information. So what can I start doing right now? My startup is at whatever point it's at. What can I start doing right now? Well, the first and most obvious thing is, if you're not yet registered with CSC, please do so. It is good for you to register with them for a whole host of reasons that I'm not going to get into in this video. But if you have an idea and you're building your idea and you feel like, I'm focused on building right now, I don't really want to put my mind on legal things, I understand that, and I respect, well, I don't respect it actually, but I understand it. But the point is, register with CSC. It will save you a lot. Just register with them. That's one. Two, understand the type of fundraising path that is open to you and your startup, and start reading up on it as much as you possibly can, and start complying with all the legal requirements that are in that particular type of fundraising. Second thing is, keep appropriate financial records. Separate your business bank account from your personal bank account, so that when you grow as a startup, or when investors start looking at you, or whether it's even friends, families, grants, competition, whatever the case is, so that when you get any kind of funds, you don't have to go through the trouble of separating your personal bank from your business bank. So have them from the beginning, have them separate, so that even if you're paying employees, you have them separate. Ensure proper documentation of every single thing, not just your financial records, but also as a company, have proper records of everything from employment to shareholding to investors to every single thing. Basically, have proper records of it. And engage a lawyer, because when you engage a lawyer, the lawyer will do all of these things for you. So engage yourselves a lawyer today. Well, that brings us to the end of the video today, guys. I hope you found it valuable and helpful to you in your journey as a founder. If you did, please subscribe to the channel so that this video can be shared to as many awesome people as yourself, so that they can view it and also gain or learn something from it. Until next time, guys, I will see you later. Bye.